see it? It's tricky. Is it going? There we are.
Oh.
Alrighty, everybody. Happy Friday. We are joining you live today from Cook Baxter Immigration in Atlanta, Georgia, where we are trying out something new, technology-wise, and we really hope you can see us.
Not my thing.
Neither me, and I think that's why we need more H-1Bs, right?
There you go. There you go.
Because not all of us are very, very adept at technology, but we are here. Hopefully, we can see ourselves, so hopefully you can see us and hear us as well. And it is Friday, December 6th, and we are going to talk to you today about federal court litigation. So as you know, we're immigration attorneys. We handle primarily immigration matters as it deals with immigration court, but that's not the only place we can go to seek relief, and that's not the only place that we should go. Sometimes the buck does not stop here. When it comes to immigration matters, we try to address them sometimes at a higher level. So as always, all your questions can be asked directly on the comments below, and we will address them because we can see them here. If you have anything that you can't ask while we're here live, you can always ask it, and we'll address it at a later time.
Right.
So Danielle, tell us, why federal court, man? You know, why federal court when we deal with immigration court most of the time? Why do we talk about federal court stuff?
Because federal court is the means now, and it has been for years, to be honest with you, but just in the last couple of years, due to delays, arbitrary denials, just all kinds of issues that we're having with immigration that we're seeing on a day-to-day basis, federal court litigation has been the best and most effective way to challenge these decisions and delays and actually get proper decisions and get decisions that should have been received a long time ago. So it's meant to cure the delays. So sometimes it's a way of premium processing a case, and other times it's a way to bring a poorly written decision or a denial before a different forum so that we can then have that decision properly challenged in a proper court before a proper forum. That's really what it comes down to. So, you know, when I first started doing a lot of federal court litigation 10, 11 years ago, the majority of it really was just delayed green card applications for no particular reason, FBI background checks, you know, that's what always the standard response would be from immigration. And so that's most of what we filed. But in the last couple of years, the nature of it has completely changed in terms of what we file quite a bit of now. Judges in federal court for employment-based cases, H-1Bs, L-1s, denials, I-140 denials, I-140 revocations, all sorts of things. And obviously the most important part about federal court litigation is the record, the underlying record, the law, are we right on the law? And we vet those cases really well. Many of them are our own cases. Many of them also come from outside referrals from other attorneys' offices, other corporate clients that are not currently our clients, or again, even just individuals who have had naturalization applications pending for several years, same thing. It's just that, you know, it's no longer limited to just those delayed green card applications. Now we're having to just attack a lot of these cases in federal court across the board. So again, H-1Bs and L-1s have become quite prominent in terms of arguments that we're having to make in federal court. And to be honest with you, we're quite successful because there's so many arbitrary decisions that are coming out of USCIS, whether it's based on the memo that came out in 2018 that talked about the new rules and the adjudication methods for H-1Bs, the itinerary rule, the employer-employee rule, you know, a lot of third-party consulting firms, things like that, and a lot of denials that we're seeing. Well, we're really able to challenge that memo in federal court as inappropriate, that it was improper legislation, and so it's provided a really good basis for us to be able to bring those cases into federal court. And now what's happened though is for the longest time, you know, we'd file these cases in federal court, and within 60, 70 days or so, the government would come back and they'd either reopen an incorrect decision, or they'd go ahead and approve a green card application, and we move on, we dismiss the case, and that's it. How it has also changed and what clients need to be prepared for is it's not always just the simplest road anymore. The government is starting to fight back. They are starting to push back. And we think sometimes they're doing that just because maybe they'll scare us off. maybe a client will decide not to push forward. But what we're seeing more and more is that clients are saying, no, we're not going to back off from this. We do know we're in the right legally. We do know a good record has been put together. And so clients are feeling more and more confident with actually pushing forward on these cases, whether it's corporate clients, or individual beneficiaries. So we've actually seen quite a bit of success.
So if I were to advise somebody, when would you tell someone to file, and when would you say don't file? Let's see what CIS does, or let's wait for a decision, or let's try to RFE or appeal. When would you actually recommend federal court?
Well, of course, a lot of these cases, again, may be new clients to us where we did not prepare the underlying petition or application or whatever it is. So the first thing I always do is to make sure that clients understand if it's a mandamus filing, meaning on a delayed application, I first want to look at the application, check the merits of the application. Are there criminal issues? Are there inadmissibility issues? Are there any fraud issues? Is there anything that is going to come to a head rather quickly if we go to federal court? Because I have to explain to clients, look, we're going to get a decision if it's a mandamus on a delayed case. So no mistake about that, we will get a decision, but we need to make sure that it's a decision you are looking for, because you're going to get one way or the other. So obviously we want to make sure it's a positive decision. In terms of the other types of actions that we filed, which are called APA claims, sometimes declaratory judgment actions, the important part about those cases, again, comes down to the record, right? There's almost never a time if a client is coming to us wanting to file a DEC action or an APA claim, it's again because it's already been denied. So if we're looking at it and we say, yeah, it was an improper denial, then it just comes down to the investment, the time, the finances, that's what it really comes down to. It's not really a question of would it be dangerous to file or not, because presumably the application's already been denied. The individual's already either out of status or has to refile or has to file another extension, what have you. So most of the time it's do we have a good enough record to go forward?
Right, and it's actually important to understand in those cases you're pretty much setting a precedent potentially. I mean, we've got Congress makes the laws, but courts interpret it really, and we have a chance through litigation to interpret it in ways that we believe are correct, and sometimes good facts make good law, and that's at the end of the day what we are reviewing when we look at cases that could potentially get denied. Why is this a case that we want to bring forward? We don't necessarily recommend it for everyone. So yeah. And so what types of cases would you say are the most that we do? I mean, here in our practice, what do you say are the typical court case?
So it really again has shifted from your standard delayed green card application to quite a bit of employment-based litigation on denied L1s and denied H1Bs. And then within that category, there's going to be another subcategory, because dependent on the type of H1B, usually and the type of L, whether it's an L1 extension or an H1B extension, change of employer versus a new petition, right? A new H1B, a new L1 where the person's not in the United States yet potentially, or they're changing their status, let's say from an F1 or so on, that's also going to determine whether something called a TRO can be filed. So a lot of times companies say, well, what can we do? This person changed employers. They came from some other employer and joined our company, and we filed an H1B change of employer and extension of status. What can we do now to get this person back to work while we're waiting on the lawsuit? Because right now they're out of work, they can't work, they can't be on payroll, but then they're potentially, they're accumulating unlawful status in the US, so that personally affects that individual and their permission to be in the United States. That's significantly damaging to both the company as well as the beneficiary. What can be done? So a lot of times that might be a situation where we can also file what's called a temporary restraining order and a request for a preliminary injunction. So the temporary restraining order, or TRO for short, is something that's filed usually in conjunction or immediately after the complaint is filed, in order to ask a judge to immediately and on an emergency basis take a look at the lawsuit and the injunction, the request for the injunction that we filed, and the judge will make a determination and a decision, sometimes having a hearing, sometimes just in writing, but will make a decision as to whether they think that the case merits the granting of a temporary restraining order, meaning are we likely to succeed on the merits? What is the damage? What's going to happen to the plaintiffs if this TRO is not granted? So sometimes sometimes that can actually be quite helpful because again, we're dealing with somebody who's here then without status, who may never have been before. They've done everything they needed to, maintaining their status, and that can be quite traumatic. So that's something we really need to look at. That's super important. So that's become a big part of federal court litigation as well.
Awesome. So we're talking not only to applicants that are, for example, that have a pending green card that's taking forever and they don't understand why, or even citizenship application, pre-interview, post-interview. We're also talking to employers and companies that have employees that they need to come and join their company or to switch over to them. We're also actually addressing a lot of immigration lawyers that may not practice federal litigation or may not even really think about it as an option to try to resolve their situation. We're all struggling with improper denials. We see it all the time. USCIS just being arbitrary and just flat out wrong on a lot of their decisions, and so another way of addressing it needs to be considered, and that's what we've been finding success with. So we are happy to talk to not just individuals and employers, but also other attorneys that are looking at expanding their practice or referring maybe cases to us to assist with taking it to the next level.
And so the one last thing that I want to mention in terms of the types of cases, only because this is really new ground here. Obviously everyone knows and is familiar with the travel ban, third version of the travel ban. It's been a couple of years now. I think there are the numbers in terms of travel ban waivers that have been submitted are somewhat sparse. I don't know what the approval rate is or the grant rate or how many decisions have been made versus how many have been filed. But I am starting to hear more and more stories of waivers that have been filed that have been pending for a year, year and a half, 2 years, hearing nothing from consulates abroad, things like that, marriage-based cases, other types as well, but the ones I've specifically heard about have been marriage-type cases, and so I did take on my first one just a few months ago, and I carefully explained to the clients, I said, look, this is new ground, there are not set processing times, it might be a tough argument to argue it's unreasonable when we don't know what reasonable necessarily is because it's not a stated processing time, right? And I went through all that. We certainly made a good argument, and in the end we were successful with a grant of the waiver of the travel ban, and that person now has her visa. And so just today I had another conversation with yet another couple that are going through similar difficulties, happened to hear about this other case and said they're going through the same thing, and one thing that I found is the language of requesting the travel ban definitely varies from consulate to consulate. There's not just this bright line title, travel ban waiver, submit this, that. It definitely takes different forms, and it's not always called the same thing. So sometimes clients might not even understand that what they're being asked to submit is in conjunction with a request for a waiver of the travel ban, but in fact that is what it is. And again, I'm looking at cases where they've still been waiting a year and a half, 2 years later. So that might be again another area where we're moving into more frequently in terms of mandamus filings for those delayed waiver applications to help to reunite families in the U.S. So
you guys may know this already, but the travel ban impacts only a few countries, but it impacts employment-based as well as family-based relationships. Petitions, typically even marriage-based cases can remain pending, or immigrant visa applications can remain in administrative processing. Countries currently on that travel ban list include Yemen, Somalia, Sudan, Syria, Iran, and I knew I was going to get myself cornered because I always forget the last one. Libya,
Venezuela, North Korea, but for different reasons though. So
right, different categories.
But
if you or someone you know has been impacted by the travel ban, I can tell you a couple of my clients, we've had these conversations. They've been stuck for actually now a couple of years. Fiancés, we've got marriages that are being, that are separated, families torn apart by this order. We, unfortunately, the Supreme Court ruled in favor of supporting the travel ban, but that doesn't mean that we can't challenge it, and that we can't try it through waivers and through federal mandamus lawsuits or lawsuits to address these delays. So. Another successful story out of Cook Baxter Immigration. Thank you, Danielle, for that. That's something that is, by the way, amazing, because not everybody everybody pretty much gives up when it comes to travel ban cases. They don't even try anymore. It is, you know, it is a big unknown. You know, people that are, you know, thinking about, well, should I even try to join my family in the U.S. Or is it a waste of time? Don't even begin that process. But we definitely have seen success with these, and yes, there is always going to be that question whether it'll work, but it's always worth a try, especially if we're talking about reuniting with your family members. So.
Yep.
So yeah, this is our update for you. Obviously, you know, the injunction is still in place with respect to the current federal lawsuit. I think that's actually a good example of how it works sometimes with the injunctions. Currently on hold right now, not enforcing the public charge rule. I know there was an announcement actually about an hour ago that I haven't gotten a chance to read yet, but it is still in place from what I read on the headlines.
Right.
That doesn't mean that we can't or shouldn't be reviewing very carefully any kind of concern regarding public charge, meaning if you have a pending family-based petition that you know, has an issue potentially with or needs a joint sponsor, the sponsor may not be sufficient, the petitioner's income may not be sufficient for purposes of the I-64 petition. So anything related to a family-based petition where we need to have a conversation about whether that person could potentially be found to be a public charge, whether they're immigrating from abroad at a U.S. consulate or adjusting status in the U.S. That's still something that we need to address. That's always been a requirement, but it's being enforced very closely these days, or very carefully, I guess.
All right.
I don't know if we have any questions.
Yeah, I don't think we have any questions, but obviously if you have any questions that come up, feel free to email us. My email is dclaffey@immigration.net, 404-949-8151.
I'll type it out for you. hcaleb@immigration.net, 404-949-8164. But I think we'll probably put it in our
yes,
our subject.
All right. Take care, everyone.
Thank you
have
guys.
a great weekend.
Happy Friday.
Bye.